Good afternoon. Welcome to today's webinar, which is going to talk about the difference between wills and trusts, kind of the age-old question when it comes to estate planning. Which one should you have? And today we're going to navigate that conversation. My name is Carrie Renner. I'm the founding attorney of Provision Law Firm in Burnsville, and I am going to spend the next half an hour with you educating a little bit on some of the differences between wills, trusts, and other ways that you can use to transfer assets. I am not alone at our firm, so I have a quick shot of our team. Our team is growing, so I don't think this isn't recent enough to capture everybody, but it's always good to know that when you're working with an attorney, that attorney is supported by a team who can do a whole lot of things, probably even better than she can or he can. And so if you work with our firm, you may work with me, you may work with one of my colleagues, and you certainly would be working with the whole team. So these are those phenomenal people. All right, so the real essence of today's conversation has to do with exactly this. What are you going to do with it, with the stuff? Whether those are contents of your garage, as in this photo here, or contents of your computer, your bank accounts, how are your wishes honored? That is the essence of what we're going to talk about today. And to do that, we're going to talk about these four key categories. We're going to define what is estate planning in a more general sense, look at probate to find out a little bit more about what that is and if it's something you want to avoid or not. Talk about ways to transfer assets, which will largely be around wills, trusts, and beneficiary designations. And then we're going to wrap up with all of the details that you should include in any estate plan. So let's start with estate planning. I think this is such a good and important question, is what is estate planning? Because estate planning can be something different for everybody. An estate plan does not mean a will. It does not mean a trust. It might be comprised of some of those things, but at its very essence, estate planning is just planning for what you want to happen when and if those curveballs happen in life and when you pass away. So before we can really talk about estate planning, we want to know what makes up a person's estate. I know the word estate or wealth transfer can be kind of a trigger word for people. A lot of times people think that this doesn't apply to them, that they are not wealthy enough to have an estate, which is simply not true. An estate is something all of us have, all of us will most likely have when we die. It's our stuff, it's our bank accounts, it's our houses, our cars. And then the planning piece has to do with those that you love. So we're talking about your family. Maybe that's your children, your spouse, or others in your family, your friends. It could be a charity you care deeply about. It might even be pets that you want to take care of. So that's where the planning side comes in. So planning how you're going to use these things to take care of those people. So I know everybody wants to get right into the guts of it and find out what is the difference between a will and a trust and which one do I need, which one should you have. And we can't do that just yet. Before we talk about wills and trusts and other ways to transfer assets at death, it's very, very important that we talk about what your goals are first. Because a person who has no goals in the world of estate planning really doesn't need anything. There are default rules in place. The state has a set of laws called the intestacy laws, and those will dictate who gets your stuff and how they get it and when they get it. So for a person who really doesn't have any goals when it comes to how their estate will transfer, then that's a perfectly fine option, is to fall back on those default rules. But the truth is, most of us do have some goals. You may not know what yours are, and that's okay. Hiring an attorney, part of their job is to advise you on what opportunities exist and really letting you know what goals you might want to be thinking about. So we're going to start with a couple common goals right now. And I would say one of the most common things I hear from people is, I don't want there to be probate when I die. They're not always sure what probate is, and we'll cover that in just a little bit. But what they're really telling me is they've heard stories about long, drawn out, expensive, stressful court proceedings, and they don't want their family to have to deal with that. That can be true about probate, not always, but probate is a court proceeding that oftentimes people want to avoid. But that's not the only court proceeding you might be planning to avoid. When it comes to your own healthcare wishes, if you're not able to make healthcare decisions for yourself and you haven't authorized anybody to do so in a legally in a legal document, then your family may have to seek a guardianship of you. That's another type of a court proceeding, or maybe that's a conservatorship when it comes to finances. So planning the transfer of your estate can really avoid a lot of different court proceedings, probate and others. Protecting privacy. When an estate goes through probate, that is a very public proceeding. There are records that are accessible to the public, and those records are going to cover things like the contents of your will, if you had one, who you may have included or excluded from that. It's going to include what your assets are, who your beneficiaries are, what your debts are, what everybody will inherit. And those are things not everybody wants the world to know about. Maybe for your own privacy, but maybe for the privacy of those who you're leaving something to. And then there's protecting the assets themselves. So these are the assets you've worked your entire life to earn. It's what's left at your death. Hopefully, not a lot. For many people, that's their goal, is to die with just one penny. Others have big legacy plans. Um, But whatever it is you leave, you want to be able to protect that so those who you want to benefit from it will actually enjoy the reaps of what you've left them. So protecting the asset is another common goal. And we can set up a person's estate to really protect that from taxes, from fees, from spend downs for people who have special needs or maybe are receiving long-term care or something like that. So we really want to be mindful of how we leave those assets. And by the same token, we want to consider the beneficiaries who will receive those assets. So not just protect the asset, but let's also think about the person who's going to receive those. I know for many of us, we can think back to a time in our life where we had to work hard to earn money, to buy or do something that we really wanted. And when those events in our life happen, those milestone events, they're very formative and they help us develop values around money, around work, around self-worth. And giving money to a young beneficiary may actually rob them of that opportunity. So you probably want to be thoughtful of how you're going to protect the beneficiary themselves. And then there's the relationships. This is such a common thread, such a common goal, I think, among most people, especially parents, that they don't even know to tell me. When I ask, what are your goals? They don't even think to say, I want my kids to still get along after I pass away. And this is definitely a top goal of many people. And how you plan for the transfer of your estate will definitely have an impact on those relationships. And then incapacity planning is a common goal. So as we age, and there are more of life's curveballs that may come our way, things like major medical events, maybe dementia, or even for younger folks, they could be looking at a car accident or another type of event that could render them unable to make their own decisions for a period of time. And the truth is, there is nobody who automatically has those rights. So if you are married, your spouse doesn't automatically get to make those decisions for you. If you have grown, mature, responsible adult children, sorry, but they don't automatically have those rights either. And if you're an 18-year-old, your parents no longer have those rights. So it's very important to legally designate somebody in documents like powers of attorney, healthcare directives, and other documents to give somebody that sort of legal authority to make decisions for you while you're still living. Planning for incapacity is a really important part of any estate plan, but because today we're going to focus on the differences between wills and trusts, we're going to skip over that today. And instead, we're going to talk about probate because we really can't talk about the differences between wills and trusts without first understanding what probate is. Now, probate is not something that every estate is going to have to go through. Probate is a court proceeding that's used to transfer assets when a person has no will at all, or the only thing they had is a will. They didn't have a trust or beneficiaries or joint ownership or other ways to transfer that asset. And so a court proceeding called probate was needed to determine who's going to get that asset and how and when. Now, is probate automatically necessary? No. I talked about some ways to avoid it, and we're going to elaborate on that in just a little bit. But if a person dies intestate, meaning no will, no plan at all, then there's going to be probate. And if a person had only a will when they died, there's going to be probate. Now, why do a lot of people want to avoid it? Well, because it's long. It's probably going to take about a year. An uncontested probate's going to take about a year in that court process. It's expensive. Usually people are going to hire a lawyer to do that. It's not something that they've had a chance to really learn about or do. And so they're going to have to pay an expert to do that for them. And it can be stressful. There are creditors calling. There are people wanting to be paid. And your lawyer is going to tell you, do not pay these people. You need to wait. And for responsible people, they don't like the feeling of having creditors out there. They don't like court proceedings. They don't like the delays. And so that can cause some stress. We talked earlier about how probates can be public matters. That's also true. People want to avoid it for that reason. And I would say the last big reason people look to avoid probate is because this can be a real financial burden on your family. Probate has built-in waiting periods, statutory waiting periods, where assets cannot be distributed. And so that means that the bills that need to be paid, things like insurances and funerals and other bills, are coming out of your loved one's pockets. And they may be reimbursed for those through that probate process, but that could be months before they get that money back. And that really can be a financial burden on many families. So probate is not the end of the world. If you find yourself in a situation where there is a probate that's going to be needed, we are happy to help you through that. But if you're in the planning phase of things, then oftentimes probate is one of those considerations, something you might want to think about avoiding. So this is where we talk about some of the differences: wills, trusts, beneficiaries, the ways that we have to transfer assets at death. But before we get into that, let's just pause for a minute. Do you really have to do anything? And the answer is no, absolutely not. There is no legal requirement that you plan. We've talked about what it means to die intestate. You've got no will. You've got no plan. There is state law that's going to decide who gets your assets. That might work. That might be consistent with what your goals are. That might not. If you plan to die intestate, you may want to find out what that's actually going to mean in your specific situation. Who will get assets, how they'll get them, and when they'll get them. So we're going to start by talking about wills. What are wills? Well, will is a legal document that you can execute when you have capacity. And that's an important thing to know, because not just anybody can execute a will. There could be a time where it's too late for a person to execute a will. If you no longer understand who your family members are, what your assets are, or where things are going to go when you pass away, where you would like them to go when you pass away, you do not have testamentary capacity. You can no longer execute a will. But let's say that you're not there and that you can execute a will. So what a will is going to allow you to do is name who's going to receive your assets when you die. It's going to allow you to name a personal representative, which is simply what we call executors in Minnesota. That's the person who's going to be in charge of your estate when you pass away. If you have minor children, then a will is a very important document to have, because that's the document where you're going to be able to name a guardian for your minor children, a person who can raise that child if you do have an untimely death. Now, wills don't always have to go through probate. There is an exception. So if the assets subject to probate, meaning they're not in a trust and they don't have beneficiaries on them, exceed $75,000 in total value, then there does need to be a probate. But if those assets that are subject to probate are less than $75,000, then there is a simpler process to transfer those assets without the need for that long drawn out probate. Now, this comes up so often. People say, my will is very clear who's going to get everything, and it's brand new, and want to list all the reasons why their will should not have to go through probate. But here is the truth. Wills are going to go through probate. I talked about an exception. If those assets subject to the will are under $75,000, then this would not be true. But as a general rule, just understand that wills, having just a will to transfer your assets, is meaning that you're going to have probate at your death. So I keep talking about assets subject to probate or subject to your will. What exactly are those assets? Which assets would go through probate when you die? And here's 3 categories of assets that would go through probate when you die if the total of them exceeds $75,000. Assets that are not jointly owned. So if you are married and you jointly own your home or a bank account with your spouse, that's not going to go through probate when you die. That survivor will likely inherit that. We're going to talk more about that in just a minute, but generally speaking, joint ownership is not going to be subject to your will or subject to probate. Assets that do not have beneficiaries designated on them would go through probate. So that means that if you've got beneficiaries, that avoids probate. Beneficiaries is a way to transfer your assets. Now, take note here, if you are divorced and you updated that estate plan after your divorce and got everything squared away, make sure that you've also checked your beneficiary designations on things like 401ks and life insurance policies. Updating your will is not going to override an old beneficiary designation. So it's a sad reality that ex-spouses receive inheritances more often than people would like to realize. And that's because people never updated the beneficiaries. So if you have a beneficiary designation, that's what's going to control, not your will. And then assets that are not in a trust are likely going to go through probate when you die. So this is another time to pause for just a minute and note that if you have created a trust in the past and you have not taken the action to fund that trust or put assets into it, those are going to go through probate in order to get there. So talk with your attorney if you've already created a trust, or call an attorney and ask, how do I properly fund that trust in order to avoid probate? So this is a real quick public service announcement on joint tenancy. So I said a minute ago, if you own your house with a spouse, you probably assume that you own it jointly and it's going to transfer to the survivor of the two of you at death. But that's not automatic. And looking at your property tax statement and seeing both of your names is not enough proof that that will not go through probate when one of you dies. So I'm going to give you some tips. Look at the deed for your house. And if you don't have it, don't worry. Lots of people can't find the deeds for their houses. You can call the county recorder's office where you live and ask them to email you a copy of the last recorded deed on your property. When you get that deed, take a look at it. It's only 1, 2, 3 pages long. And what you want to see is not only both of your names, but also these magic words, which are joint tenants. If you don't see the words joint tenants on your deed, then there are no rights of survivorship on that property. And that's probably something you're going to want to take care of. So we're going to switch gears now and talk about beneficiary designations. Beneficiary designations are something most people are familiar with. You probably already have them on things like 401ks and life insurance. Again, you have to have capacity to be able to name a beneficiary on an account. And if you don't have capacity, only a certain types of powers of attorney will allow your attorney, in fact, to do that for you. So make sure you consult with a legal professional to know which types of powers of attorney you should have for that purpose. But obviously, with a beneficiary designation, you get to choose who's going to get those assets when you die. You don't get a lot by way of backup plans, but you do get to choose usually a primary and a contingent beneficiary. This is going to keep those assets out of probate, meaning these will not be subject to your will. These are kind of a different category of asset transfer. Another thing to know about beneficiary designations is they lack any sort of rules or structure. So maybe you've taken out a life insurance policy for the purpose of paying for your funeral, and you've named your 3 kids as beneficiaries on that life insurance policy. And your assumption is they're going to use that to pay for your funeral. Well, you can hope that's the case and have that conversation and tell them that's what you want to happen. But there is nothing about that beneficiary designation that's going to ensure that that will happen. So beneficiary designations simply say this is who gets that property. What they do with it after that is up to them. So when you're making assumptions about how money is going to be used, um, be careful. So when you think of a beneficiary designation, you just have to know that it's really kind of like giving them the money, the kids or whoever those beneficiaries are, and then knowing that there's still bills out there that need to be paid and that you hope they're going to come together and use that life insurance money to pay for the funeral or to take the cash from the bank account and pay the expenses of the house until the house gets sold. But there's nothing that's going to guarantee that that's going to happen. So you really only want to use beneficiary designations when you can just trust that the good faith of these beneficiaries are going to carry that out without the need for any hard and fast rules. So a transfer and death deed is kind of like putting a beneficiary designation on your house. It's a deed you can record with the county that says, when I die, this is who's going to own my property. Now, we talked a minute ago about how you can find out if you're joint tenants on your property with your spouse. And usually joint tenancy is how spouses want to own their property. But if you use a transfer on death deed, let's say to leave property, your house, to your kids, they're most likely not going to own that in joint tenancy. They're going to have a different type of ownership structure, which is called tenants in common. So if you have 2 kids, they're most likely going to own it 50-50. This transfer on death deed, because it's a beneficiary designation, it doesn't put anyone in charge. Now you might say, well, I have a will over here and I've named my oldest child as the personal representative. So they're the one who's in charge of selling my house. But that's not true if you've used a transfer and death deed, because remember, when you use that deed, you've taken that out of the power, out of the control of that will. You took it out of probate. That's why you did it. And now you've got nobody in charge. You just have co-owners of property. And those co-owners have 100% right to occupy that property. So if you've got one child living at home and you use a transfer on death deed, it might be tough for the others to get that child still living at home to agree to sell. That's their home. They're probably not going to be in a big hurry to move out and sell that property. And they do have 100% right to live there. And they also have, everybody has 100% responsibility for the bills on this property. So if you leave it to 2 of them and one of them is responsible and they're paying their share of the bills and the other isn't, that tax assessor isn't going to send a letter just to the non-compliant child to say, hey, you owe 50% of the property taxes here. The whole property is going to get a lien put against it for failure to pay those property taxes. That's going to affect everybody's credit. That will affect all of them. And here's the thing that a lot of people don't realize is when you use a transfer on death deed to transfer property to somebody, your kids or anybody else, they become the owners of that property. And in Minnesota, when a person owns property, they can't sell it without the consent of their spouse. So you might list your 3 children on that transfer on death deed that says, I want my 3 kids to own this house when I die. Well, guess what? If all 3 are married, it's going to take the consent of 6 of them to sell that property. There are ways around that, but not through a transfer on death deed. Then we'd want to be looking at other methods to transfer that property. And trust would be one of those methods. So now we'll talk about how trusts differ from what we've talked about so far. So trusts do not go through probate, and they do let you put rules in them. One of your rules is probably going to be that, or will definitely be, that there's a trustee in charge. This is the person who's going to sell that house, who's going to use the assets to pay the bills, file the tax returns. And when you have those rules, not only do you name a trustee, but you give them access to some of the cash so that they can use that to pay those bills. They're going to have immediate access to that cash if it's set up properly. No waiting for a death certificate, no waiting for probate, immediate access to that cash so that they're paying for your funeral with your assets and not theirs. Trusts allow for some incapacity planning. So if you ever have dementia or live with an illness later in life and are relying on the help of others, a trust can allow for that, or does allow for that. If you ever become vulnerable and maybe you've been taken advantage of, exploited in some way, a trust can help protect you from that. If you've got a large estate, trusts can help minimize those taxes, and they can even offer creditor protection for your beneficiaries. So maybe you've got a beneficiary who's in a career that's a highly litigious type of a career, like a medical field or something, where there's a high likelihood they could be sued at some point during their career. You may want to consider a trust to protect that beneficiary from creditor claims. The structure of a trust is basically this. There's three roles that are going to be played in any trust: settlor, trustee, and beneficiary. And what that solid line represents is when you get to act in those roles. And what that dashed line represents is when somebody other than you will act in those roles. So the settlor is just simply the person who creates the trust, and that's always going to be you. The role of the trustee is an important one. That's who gets to access the money, spend it, gift it, invest it, make decisions about it. And if you have capacity, you want that to be you, most likely. When you die, that can't be you. And if you ever become incapacitated during your lifetime, you probably don't want that to be you. You probably want somebody else to assist in that decision making. And the role of the beneficiary, that's the one everybody wants. That's the person who gets to enjoy the assets of the trust. That is you as long as you're living, and only after you die does somebody else take over in that beneficiary role. So creating a trust does not mean that you're losing access. It does not mean that you're barred from your own money in any way. But a quick note here is what I'm talking about is revocable living trusts. There are a whole nother type of trust called irrevocable trusts. We are not talking about those today. Those are trusts often used for tax planning for high net worth individuals. And those are trusts where you are relinquishing access, at least in some degree, to your assets. So we're focusing on the column on the left. This is the most common type of trust that would be used. This is common because it's really there to help that with that transfer at death, to keep family harmony, really to touch on a lot of those goals we started with at the beginning. And you do maintain access to those assets during your lifetime. So there's lots of different reasons people may want to consider having trusts, but here's 10. They avoid probate. They do make for a smooth transition at death. There's one person in charge, not 3, 4, 5, or 6 or more who are trying to have to make decisions about selling real estate and other important decisions together. If you own multiple properties, those are very likely to be subject to probate if you don't have a trust. So that could be a time to be thinking about trusts. If you've got a cabin you want to try to keep in the family and you want the kids to still get along, a trust is probably going to be the way to do that. There are other mechanisms, but a trust can be a good one. If you've got a blended family, a disabled loved one who you want to leave assets to and not disrupt any benefits they're receiving, that's an important reason for a trust. Young people, not necessarily minors only, but even young people, 20s, maybe even 30s. Maybe they would benefit from a little help managing their money as they gain some life experience. Any beneficiary who deals with addiction or mental health issues would certainly benefit from a trust. Number 9 talks about a corporate entity to administer your estate. So if you say, my kids they're out of state, or they're just too busy, or I just really don't have anybody who could sell the house and deal with this stuff when I die, you may very well want to hire somebody to do that, and we can help with that. That's probably going to dictate the need for a trust if you're going to hire somebody to do the administration for you. And then if you're of a high net worth over $3 million in Minnesota for any individual, you'd certainly want to be looking at trusts for potential estate tax planning. All right, that was a lot of information. So I am just going to recap these real quickly with option 1. Do nothing. This is an option. This is a popular option. And when people come to me and they say, I just want this to be extremely simple, then I say, this is certainly an option. You can do nothing, and then the intestacy laws will kick in, and that will be your plan. But that's not typically consistent with people's goals, so it's not a very good option to choose. So sometimes people want to try to DIY this. They go to the bank and they say, I know, I can just add my child as a joint owner here. Maybe I'll add them as a joint owner on my house. And I know that joint ownership is going to transfer seamlessly when I die. But that can be a whole nother can of worms, because what that essentially means is you and that joint owner share that asset. If it's a bank account, any one of you can withdraw those funds. There is no responsibility of a fiduciary, of acting in somebody else's best interest. So that can really be a slippery slope. And if you're looking at it from the perspective of maybe your child who you've put on that account, think about them and their situation. Are they ever going to get sued, file bankruptcy, get divorced? Is that going to affect your asset? Do they have children who are going to be applying for financial aid for college? Are they going to have to report this as an asset of theirs and be affected in that way? So think that through. Generally, joint ownership should be reserved for husbands, wives, spouses, life partners, usually not parents and children. So wills can be a great way to transfer assets. If you are trying to include somebody who the state wouldn't recognize normally, like maybe a stepchild. We talked with a gentleman recently whose father just passed away, only this wasn't his father legally, it was a stepfather. He was very close to his dad, his stepfather. He even changed his last name years ago to match his stepfather's, but he was never legally adopted. And when his dad passed away recently, he called our office to find out how does he get the house. And unfortunately, he was told there's nothing there for him. Everything will go to a son who is estranged from the person who passed away. That's a really sad result, and that could have been changed with a simple will. But just know that wills go through probate. So sometimes people are looking for ways to avoid probate, and beneficiary designations can be one of those ways. Beneficiary designations can be great, sometimes in conjunction with other things, sometimes all by themselves, but you want to proceed with caution when using beneficiary designations and transfer on death deeds. There are no rules when you use beneficiary designations. You don't get to tell people what to do with that money or that property, and so you're really relying on their good faith to work together and do what you would expect them to do. And so if nothing else feels like a great option, then usually trusts are going to answer those or solve those potential problems. Trusts are going to keep things out of probate. They're going to put somebody in charge. That person in charge is required to look out for the best interests of all beneficiaries. So they don't get to come in and make selfish decisions or not pay bills. And so it kind of keeps the playing field level and makes sure everybody is looked after. When you're doing estate planning, I know we're really trying to keep this just to wills and trusts today and what those differences are, but I want to make sure that I cover for you some of the other details that you should have that should accompany wills and trusts. In addition to the incapacity planning that we're not really touching on today, these are other things that that should be a part of any good estate plan. So make sure that they know what your wishes are, they know where to find things, Write a letter, write a family letter. That can be a great way to ease some of the stress when you pass away, and it's the very best keepsake that a family could have. So, here's some takeaways for you. Don't start thinking about wills and trusts until you've thought about what your goals are. We've talked about some at the beginning, like keeping people out of court, keeping those relationships whole, protecting assets and beneficiaries. Think about what those goals are in your own words, and then you can start to understand what your options are: wills, trusts, transfer and death deeds. But choose the right options for your situation and your goals. I would not advise doing this yourself. If you haven't had experience in doing this type of work, it's very easy to miss a step. Um, a, an online program is probably not going to ask you all the pointed questions that it should be asking you. So I would steer clear of those. There's just a lot at stake. And there's a lot of free information out there. So whether it's a webinar like this or a free consultation with our office or another attorney somewhere, take advantage of information where you can get it. And then celebrate your plan. That is it for today. Thank you for joining us. We do offer complimentary strategy sessions. So those are usually 30 minutes over the phone. Those can be scheduled on our website, which is provisionlawfirm.com, or you can call our office to schedule those, 952-563-0152. And those are always with one of our estate planning attorneys. Thank you and have a wonderful day.